Court is calling 2026 CR 003850 and 2026 CR 003, 2026 CR 002351, State versus Jose Nino. Can I have parties announced?
State.
Valerie Headland for Jose Nino.
And are you Mr. Nino? Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Nino, and each cause number, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes.
State and the cause number ending in 50, are you proceeding on the indictment as presented?
We are, Judge.
On with the enhancements in counts 1 and counts 2?
Yes, Judge, and count 1 and count 2.
Okay. And cause number ending in 51, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Nino, and each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with aggravated assault with a deadly weapon in count 1 and count 2. Normally, that's a second-degree felony. The state is proceeding on an enhancement allegation. If the enhancement allegation is proven to be true, your range of punishment will be from 5 to 99 years or life in prison and up to a $10,000 fine. You're also charged with unlawfully carrying a weapon with a felony conviction as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each cause number?
Yes, yes.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Nino, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Buckle up, guys. Today, we're stepping inside a courtroom where a routine hearing quickly reveals just how serious the charges really are. As the judge carefully explains the allegations, the defendant learns he could face anywhere from 5 years of life in prison if the enhancement is proven. Every question confirms that he's fully aware of the rights he is about to give up, setting the stage for a case where every answer carries enormous consequences.
And the cause number ending in 50 and the cause number ending in 51. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea in 50, you to plead to count 1 and count 2. You agree that you've been previously convicted of 1 or more felonies for purposes of enhancement. Punishment is to be assessed at 10 years in the prison. It's run concurrent with 2026 CR 002351. And the 51 case, punishment is to be assessed at 10 years. There are no applications. And it is run concurrent with 2026 CR 003850. Did you understand in cause number ending in 50, if the court determines that a weapon was used, there will be an affirmative finding of deadly weapon?
Yes, yes.
All right. Did you understand that to be the plea in each of the cause numbers?
Yes, sir.
Defense state?
Yes, Judge.
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Judge.
Counsel, any such motions?
No.
Again, the court will find that defendant has knowingly and voluntarily waived his right to jury trial in each cause number. In cause number 50, to counts 1 and count 2, how do you plead? Guilty, not guilty, or no contest?
No contest, Judge.
And to the enhancements, how do you plead? True or not true?
True, Judge.
And cause number ending in 51 to the offense, how do you plead? State any evidence to support the defendant's pleas.
Judge, offer state exhibit number 1 and all attachments in both cases.
And no objection.
All right, state to me the excuse. Thank you. And each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right?
All right, guys, now the pressure reaches another level as the courtroom shifts from explaining the case to locking in the defendant's decision. The plea agreement is laid out in detail. Appeal rights are waived, and guilty pleas are formally entered, with no live witnesses needed. The judge accepts the evidence, making it clear that the legal process has crossed the point of no return, and the final outcome is now only moments away.
Accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty of counts 1 and counts 2 under cause number 50. The court will find an affirmative finding of deadly weapon in each count. The court will find the enhancement true based upon your plea true and based upon states exhibits 1 and attachments. And in 5-1, the court will find the evidence is sufficient to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, just that you follow the proposed plea.
And cause number 2026 CR 002351. The court will follow your agreement. The court will find you guilty, sentence you to 10 years in the prison. Give you credit for any time served. This is run concurrent with 2026 CR 003850. There's to be no residing in households with minors and no unsupervised contact with minors. In that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission.
Now comes the moment everyone has been waiting for. After reviewing the submitted evidence, the judge officially finds the defendant guilty, confirms a deadly weapon finding, and follows a negotiated plea agreement. A 10-year prison sentence is handed down, along with strict conditions that will continue long after incarceration. What began as a hearing has now become a life-changing conviction with lasting consequences.
Court is finding you guilty of counts 1 and counts 2. Count 1 and count 2 are to run concurrently. And this is to run concurrently with 2026 CR 002351. The enhancement is true. This court is going to sentence you to 10 years in the prison. Give you credit for any time served. There's an affirmative finding of deadly weapon in counts 1 and count 2. There's to be no residing in households with minors. And no unsupervised contact with minors. Did you review the document entitled Trial Court Certification with your attorney? Did you understand it and sign it?
Yes, Judge.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Judge.
All right, how old are you?
45 years.
45. You got to make some changes in your life. If you don't make changes in your life, you know what's going to end up happening? You're going to end up in prison for the rest of your natural life, or either something is going to go wrong because you easily could have been killed this night. You understand? So whatever is going on with you mentally, or whatever's causing you to behave this way, when you go back to custody, you need to try to figure it out and make changes. You understand? All right, good luck to you, okay? Oh, thank you. God bless you too.
Judge, I think he's got 207 days, that he just wanted to ensure that.
Oh, the clerks are in charge of that. Okay,
Thank you, Judge.
you're welcome. Thank you.
This final chapter delivers more than just another sentence. It delivers a warning about the future. The judge orders a second prison term to run concurrently before speaking directly to the defendant, explaining that unless he changes his life, he could spend the rest of it behind bars. It's a rare moment where the courtroom shifts from punishment to personal advice, ending the hearing on a powerful and unforgettable note. If you enjoyed this courtroom breakdown, don't forget to like the video, subscribe to the channel, and turn on notifications so you never miss our next case. Thanks for watching, and we'll see you in the next video.